Again, the Supreme Court in India had decided such a situation, not on virtual reality, but had laid down the principle of what is going to be original in a particular case, which was, I think, Eastern Book Depot versus Modak. This was followed subsequently in Chancellor's Masters, and I think this was Justice Bhatt's decision. Third thing is probably merger doctrines is going to apply. This is something which is, I think, very important. The idea and expression are intrinsically connected to each other. If they are intrinsically connected to each other, possibly there is going to be no copyright. So in India, generally the courts would refuse protection to an idea that can only be expressed in one manner. So a virtual world is bound to have certain similarities. So a person cannot claim that this is original work. He has to actually show the fact that where does reality end, where does virtual reality start, and how do you differentiate between this. This is something which I am going to quickly go. This is copyright protection by the Copyright Office in India. Now, for the purposes of computer codes, the law is pretty straightforward. Computer programs are considered as the embodying computer work in a virtual reality would be considered as literary work, and they will be protected as literary work under the copyright laws in India. As for the user interface and other aspects of virtual reality, there is no set provision or policy by the Copyright Office. I would go for a single registration instead of, because virtual reality is a constantly changing thing depending on how the user is doing it. It is not a set medium like a video game, but constantly changing because of the presence of the user. So there are benefits which are going to arise. Obviously, we can avoid the claims of innocent infringement, presumption of validity is there, and the burden of proof automatically shifts. So filing for a copyright registration for a virtual reality work is a good thing. I think it's going to make a lot of our life very simpler. Now there are many acts, many points, but I'm just going to focus on the balancing act. What should be the scope of protection for copyright in a VR? These are the 4 points which I think should be applied practically on any of the VR world. It should not be a mere or a direct copy of something existing. It should be an original expression of reality, and it should be conveyed. It should be a creative rendering and a creative extension of real life. So creative rendering would be akin to a photograph. You take a photograph, it is a real work, and you have taken a photograph of a real work that is protectable as a copyright. Likewise, there are certain creative extensions to life. I may not be able to wave my hands and fly over here, but I can do the same thing in virtual world. So that is again a creative extension of life. Now again, there are no instances of infringement of VR in India. How am I, Dr. Reddy, on time?
Yeah, yes, still about 3 minutes, but the question hours should be infringing into their T rights.
Ah, okay. So, all right. I will quickly get into the 2 slides, and I think one would be a conclusion and one would be this. Guidelines for VR infringement, probably which the courts will apply, are going to be these. First, the person who is infringing has to have access to the work. Oddly enough, Indian laws somehow do not talk about access, because a work which is independently developed, but if the violator had access to it, then there is a presumption of infringement. That is a portion which is somehow not covered a lot over here. Proof of independent development, protecting original expression, not idea. Point number 4 onwards, it's all about virtual reality, structures, sequences, file structures, subroutines. If they are similar, it would amount to a virtual reality infringement. Naming of visual displays, this would again fall into the realm of copyright infringement. Single virtual work in a number of displays, again infringement. Command sequence, syntaxes, again infringement, even if the visual display is different. Literal copying is pretty much an infringement. Again, non-literal copying, India does not have a test which has been laid down for non-literal copying. Non-literal copying is very simple. The program code is not the same, but the overlying work is similar. So probably the test which is used in USA, which I found to be quite useful, should be applied in India, where you use the scale of abstraction to see what is the scope of protection. Is the essential elements being copied? Are the original expressions of the whole work being copied? Then again, the other aspects which come into is what are the industry standards and compatibility. This is something similar to a standard essential patents requirement where you require a certain virtual world to exist in a certain manner. Therefore, such a industry requirement would keep you out of an infringement issue. Now I'm just quickly going to run to the conclusion. According to me, only the surface has been scratched. A lot has to be done on it. Legal practice and advice, obviously we all lawyers have to be very creative about it. There are no amendments, no guidelines in the Indian laws, so courts will have to come up with some creative interpretations. Laws will be changed and amended, and I think that's the future. And thank you so much for listening. Thank you.